Good evening, class. This is going to be our fourth session, and tonight I'm going to actually do the lecture in two parts, and this one I'll conclude or work with Chapter 13 tonight, and then first thing tomorrow I'll get Chapter 14 dealing with intellectual property. These are two pretty important chapters. The course, as you know, is entitled Legal Issues for Management, and both of these chapters bring about areas that management has some serious issues to deal with. Chapter 13 is entitled Strict Liability and Product Liability, and it is really more about product liability than anything. If you look at the text, you'll see that there's only about the first page or two is devoted to strict liability. The rest of it moves immediately into product liability. So let me touch on them quickly. As you know, we've talked about in fact, I'm not sure we did talk about negligence, but negligence is a concept where you have a duty of care. We've imposed a duty of care on some activity, and if you engage in an activity that causes an injury, then you're going to be responsible for it. But it has some limitations on it. In other words, you can do some things that contribute to the injury, and therefore it's not an absolute liability on your part. That's in contrast to the overall concept of strict liability. And strict liability, simply stated, is it's an activity that is so abnormally dangerous that no matter why someone gets injured, you are liable. There is going to be fault attached to your actions if anyone is injured in any way. And the classic case are what we call the blasting cases, which I don't think a lot of that's done in the United States anymore, except maybe on ski slopes in the early morning hours before the crowds get out there. But other than that, this concept goes back in the days when there was blasting done by mines and whatnot, and it was possible that dynamite could go off the wrong way, or send the charge the wrong way, or the reverberations from the explosion, and things that no one expected would be damaged, be it a house that was a half a mile away and it knocked a tree over and broke into the roof, or whatever the basis was. The idea is that an activity like blasting, once you light the fuse and the blast goes off, who knows what's going to happen, and therefore if anyone is injured or there's an injury, damage of some kind, you're going to be responsible. So it's an hazardous activity. Strict liability attaches to ultra-hazardous activities, and those where there's an abnormal danger, which generally means that it's impossible to control the outcome of whatever that activity is. And the text goes on to talk to you about wild animals. If someone keeps wild animals, and you read about it now and then in the newspaper where someone had a pet tiger cub or mountain lion or what have you, and the thing gets out and kills the local pets or what have you, or mauls someone, that's going to be an abnormally dangerous activity because you have no control over a wild animal. And so in that setting, you're going to find strict liability. In other words, it happens, someone's hurt, you're responsible. Okay, now let me get more to the meat of this thing, and this is where it is an issue for management. And this is this concept of product liability. And it has to do, to a large measure, with manufacturing, and at least that's where it started. But it's spread beyond that. So you can have, it has to do with a product that causes injury to people. So you can have products that are made by a manufacturer that you use in daily activities, a lawnmower, a chainsaw, a stove that might explode or catch fire, a chainsaw where the chain flies off, a lawnmower where the blade flies off or it throws dirt and rocks and so forth out the intake area. And you can also have situations where a drug is improperly composed, or something goes wrong with its application, and it creates injury, that's the area of product liability. A big area in that would be medical devices, and that's an area of a great deal of concern by manufacturers and people who've invented various medical devices that are used inside the body. You're never quite sure that they're 100% fail-proof and fail-safe, and you can't know when they might in fact cause harm or an injury. And so we have this concept of product liability, and there's actually three bases upon which a lawsuit would be brought. One is based on negligence. The other one is based on fraudulent misrepresentation. And the third one is based on what we call strict product liability. And that's really going to be the heart of what I'm going to talk about tonight. But what I want to remind you is that if you're an attorney and someone comes to you and says this product is defective and I was injured, a lawyer will bring his lawsuit against the defendant using all three bases or causes of action, if you will, even though the strength of his case, or the strongest case he might have, comes under the third area, which is strict product liability. But he can bring the suit on the basis of negligence. In other words, he can show that the manufacturer failed to have a duty of care in the way he constructed the product or the device. The other area would be for misrepresentation, which tends to be more focused in the area of advertising and labeling. So you can put a product out there, and if you make claims that the product can do this or can do that and it can't, then that would be a products liability case where the product in fact doesn't accomplish what it's supposed to or has been advertised to perform, and it doesn't. So you've got the negligence theory for a product that doesn't work or injures someone. You've got the misrepresentation theory for situations where a product just doesn't do what the manufacturer touts it to do. And the last one, which is the core of what we're going to talk about, is called strict product liability. Now, the concept here is not as onerous as strict liability, as the blasting case is, but it's not far away in that it's a public policy statement, so to speak, or a public policy determination that says that consumers need to be protected from unsafe products. And then it goes on to say that manufacturers should not escape liability because of their relationship to the end user. Now, without benefit of a visual, let me lay it out for you this way. Imagine at the top of the tier you have the manufacturer in a box, and below that you have the distributor. So the manufacturer makes the product, he sells it to the distributor then takes the product and puts it out into the retail stores, and then you or I come in as a customer and we buy that item. All right, so let's suppose my example of a chainsaw. So you have Toro. Let's say Toro makes chainsaws, or Skill makes chainsaws. And so they make this chainsaw, they sell it to a distributor for X dollars. The distributor takes it, he marks it up, sells it to the retail store. The retail stores, there's 10 or 12 retail stores, let's say, in this area, they all stock the Toro chainsaw. I come in and buy it. Now, I bought the saw from the retail store, from a Home Depot, let's say. And we have a bill of sale, or a receipt rather, that says that I paid $150 for this chainsaw. And that's the contractual relationship between me and Home Depot where I bought the chainsaw. But I want to have the manufacturer held liable because I got hurt with the chainsaw, or somebody got hurt in my family, whatever, but there was an injury caused by my chainsaw. Well, in the law, there's a concept called privity of contract, P-R-I-V-I-T-Y. And privity of contract is the idea that two people entered into an agreement with one another to provide a service or provide a product for which the other one's going to pay. And so there was privity of contract between me and Home Depot because I gave them $150 and they gave me the chainsaw. Now, under almost any other legal setting, that's the transaction, that's the privity, and no one else is responsible for whatever goes wrong or might go wrong after I have the product. In products liability, that is not the case. In products liability, even though the contract of purchase was between me and Home Depot, you trace it all the way back up through the distributor to Toro Manufacturing Company. And all of those people become defendants in the lawsuit. So under a products liability lawsuit, you are able to sue the manufacturer, which is where you really want to be. You really want to hit that manufacturer. They have the money. They have got insurance to a certain extent on some of their products. But the fact remains that they are the ones who manufactured this product, made it, designed it, constructed it, and we're saying that that chainsaw had defects in it that caused my injury. And so the public policy is that if I'm a consumer and I get a product that's unsafe, then I shouldn't have to bear the brunt of that by myself. And the second part is that if you have that setting where I got a chainsaw from Home Depot, the law is saying we're going to go all the way back to the manufacturer. The manufacturer can be subject to a lawsuit on a product that has caused an injury and therefore is an unsafe product, and you can go against the manufacturer even though there's no privity of contract, meaning I didn't deal directly with Toro to buy that chainsaw. I bought it through the chain of sales down to the retail store. Okay? Now, I'd like you to look at page 296, and I'd like you to understand and know this concept. On the left-hand side of the column, you'll see on 296, you'll see the red heading says the requirements for strict product liability. It means that in order to make out a case for strict product liability, you have to show the 6 items, the 6 components or elements, if you will, of the concept of strict product liability. And they are that the product must be in a defective condition when the defendant sells it. So my Toro chainsaw had to have something wrong with it when it was sold to me. We'll talk about what that can be in a moment. Number 2, the defendant normally must be engaged in the business of selling or otherwise distributing the product. So in this case, Toro is in the business of making and selling a product. They sell to the distributor. They're in the business of selling a product. They sell it to Home Depot. Home Depot's in the business of selling a product. And therefore, all of these people in the chain of sale would fall under normally engaged in the business of selling a product. Then it says the product must be unreasonably dangerous to the user or consumer because of its defective condition. Okay? It needs to be unreasonably dangerous. We'll come back to that definition in a second. The fourth one is the plaintiff must incur physical harm or injury by use of the product. And that's pretty simple. Obviously, you've got to have that. You've got to show that there's a connection between my use of the product and my injury. Number 5, the defective condition must be the proximate cause of the injury. And what that means is if I wouldn't have been injured if the chain hadn't flown off the saw. So that was the proximate cause of my injury, was the chain flying off the saw and hitting my ankle and lacerating me badly or what have you. So that is the proximate cause. That if I dropped the saw and fell and I cut myself badly up in a tree because I fell out of the tree and the saw kicked back, but the proximate cause of that injury was really my arm. I fell out of the tree and cut my arm. It wasn't the saw didn't cause my injury. Okay, so that's the proximate cause concept. And then lastly, the goods must not have been substituted or substantially changed before the product was sold. Now, what that talks about is aftermarket, where you buy a product and then you modify it later. Or let's suppose Toro sells it to the distributor, sells it to Home Depot, and for whatever reason Home Depot changes the guard, the guard on the chain, or they make some minor adjustment that they think's better for it, or makes it safer, whatever they might do, but they've modified the design. And in that setting, it's going to let the manufacturer off the hook, because the idea is the product's defective. It has to have been defective when it went out of the manufacturer's factory. And if it's been, it's kind of like the chain of evidence in a criminal case. If the evidence has been tampered with, then it's been poisoned, so to speak. So if there's been aftermarket adjustments made, for example, on a motorcycle, you buy a motorcycle, that's a product, right? That's a product that can have a defect in it. But if you take that motorcycle out and have the engine bored out so it has more power, or it's quicker, or you change any of the working parts of it, then you've modified that aftermarket. And the manufacturer, if there's an injury because of the motorcycle and there's a defective condition to it, you've got a problem, because that motorcycle's been modified, and now that chain of evidence is not direct and untouched. It's been possibly tampered with because of what someone else did to the product after it came out of the factory. So that's the idea of no aftermarket changes. In fact, the wording is that the goods must not have been substantially changed. So I'm going to want you to know these 6 requirements and have an idea of what they're all about. Okay, now proving a defective condition. Proving a defective condition. You have to show 2 things. One, that the product was unreasonably dangerous beyond the expectations of the consumer. So the product has to have been unreasonably dangerous beyond the expectations. So let's suppose, in my saw example, that this manufacturer manufactured a saw and didn't have a front hand guard on it, didn't have a guard right up at the front where the saw comes in to catch the motor, and other people had that guard on there. Okay, then that's going to be unreasonably dangerous beyond my expectations, because I would expect that the manufacturer would put something on the front of the saw that would guard my hand a little bit. So let's suppose the manufacturer didn't do that for whatever reason. They said you don't need it, or whatever it might be. Okay, in that setting, this product is unreasonably dangerous beyond my expectations as a normal consumer. And now, the second part of that, to show a defective condition, is that there was a less dangerous alternative available to the manufacturer. In other words, there's something he could have done to make the product safer that was economically feasible. So in other words, the law is not saying you have to make this product. Sometimes we lawyers on the defense side wonder about that, because it seems sometimes that clearly the person that used the product used it wrong, or didn't use their head and got hurt, and now all of a sudden it's all our fault. But this is an idea to try to reduce that a little bit by saying that if a less dangerous alternative is economically feasible, you should use that. And if you didn't, then we will hold you responsible. So in my example with the chainsaw, if all I had to do was put a plastic shield in front where the chain meets the motor, and one of my hands is up holding on top of that, holding the saw like so. Okay, I'll move my hands around here. If you're holding it up in this fashion, and this hand is closest to the motor, if you put a little fence up above that, a plastic fence, it's going to help you if your hand glances off the top of the chainsaw and it runs towards the blade, but it hits the plastic shield. Well, if that's a $5 or $10 part to put on there, then you're able to show that that product is defective because a reasonable alternative was available, it was economically feasible, and you failed to do it. So those are the 2 things that make a product defective. Number 1, it's dangerous beyond the expectations of the consumer, and number 2, a less dangerous alternative was possible. It wasn't onerously expensive, and you didn't do it. You didn't use it. Now, On the other hand, let's suppose with my example of the saw, that the saw is going to sell for 150, and this is kind of way out there, but it'll give you an idea of the concept. But to put the kind of guard that would really guarantee almost fail-safe any injury, it's going to cost you $50. Well, that's a third of the sales price. So is that economically feasible? And the idea is no. So you're trying to balance that the manufacturer's got certain hard expenses to produce the product, and you can't ask him to go spend half of his potential profit on making something to the point where, you know, there's no conceivable way you could get injured. And in my experience, there's always a conceivable way someone can get injured with any product. But in any event, that's the idea. Okay. Okay. Now, let's talk about the defects. And here are the defects that are possible. You can have manufacturer's defects, and you can have design defects. All right. And the third one is inadequate warnings, which is the real big one. This is where the lawyers really can make their money. But let's go to the first two. One is manufacturer's defects. Okay, so you would have to prove, in my chainsaw example, you would have to prove that there was something wrong in the assembly of the saw, in the testing of the saw, perhaps in the materials that were used, perhaps the quality control systems are suspect. So in a trial, if I was going to trial, I'd be bringing on experts who looked at this, examined the saw that caused the injury, and they'd say, this design is improper, and here's why. And they would know the industry standards for designing the chainsaw. So they would say that they, I'm sorry, not design, they assembled it wrong. That the method of assembling this was not the best way or the most standard way. I didn't mean design, I meant assembly. The testing of it, how they tested how much pressure it could take, how many RPMs it could run without shaking or getting unstable. And then what kind of materials did they use? Did they use an aluminum that wasn't really strong enough, so the result was the saw collapsed, or that sort of thing. And then lastly, as they came off the production line, was the quality control part so shoddy that they never ran the saw at all to make sure the blades worked properly. They just put it in the box and took it down to the distributor and sold it, and then from there to Home Depot to me. So those are your manufacturer's defects: assembling it improperly, testing it improperly or inadequately, materials, using wrong materials or materials that didn't hold up to do the job, and then lastly the quality control part of it. Excuse me. The next one is the design defects, and that really has to do with the engineering design of the product. And here you would bring in people who are engineers with background in those areas, and they would test it, and they would look and see the way the thing was designed, and they would determine whether or not they felt maybe the sprocket at the far end of the saw is too small or not durable enough. And so as the saw runs, after 20 hours of use, the spool in the front weakens, and it can throw the blade, throw the chain off or what have you, something like that. So in that setting, you have an expert, an engineering expert who designs chainsaws, come in and say this design is defective, and therefore you have a defective product. And when you have a defective product, that's when you have liability. Okay. And then inadequate warnings I'll take up in a moment, last. But here's the thing about design defects. And here's the thing about manufacturing, when you talk about it as a manager. And that is, if you take a medical product, a medical device that's used in a surgery of some kind, you take the heart valve or a shoulder joint or a bulge socket for the hip, all the kinds of things that are products that are made. Companies have to consider what the possible risks are of that product failing. And so there are times when you get products that might do well for people, let's say in the medical area, a device or a piece of material that can go in the body that helps stabilize the bone structure, what have you. But if the manufacturer has too much uncertainty about how well that product would hold up, then he may never bring that product to market. And so that's a problem you can have, that managers have from a legal standpoint, is this whole area of products liability. because it can end up costing a company a lot of money if they get nailed for products liability. What happens is, and let me go a little further, how it can affect economically. I've been involved in some startup work, and was involved with a group. We had a medical device. I think I might have mentioned to you. If I didn't, I certainly will when we get to intellectual property shortly. But we had a medical device, and one of the things you have to worry about with our medical device dealt with the heart, and it pumped blood through the heart during open heart surgery. Now, you're trying to get venture capitalists to put money into doing the additional testing and whatnot that has to be done to get approvals to make it. Well, if the venture capitalists think it's too risky because of products liability potentials, because of the danger of litigation over products liability, they're not going to put $5 million in the development of your product. Likewise, if you go to get insurance companies are going to look at it and say, yeah, it could help people out medically, but you know what? It could do a lot of harm too. And on that basis, I don't think we want to insure it. Or you get the device built, you get some venture capital money in it, you take it to a Bentley Labs, which does all heart type equipment, monitors and stuff. Excuse me. And they decide they're not going to make it. You can't find a manufacturer to make it because they're concerned about product liability issues. So you can see how that can stifle innovation in the area of various medical devices and what have you, because they're a product. And other products the same way can be not get to market as fast as you'd like them to, or not get to market in a way that would really make them useful, because the designs have to be try to be so fail-safe that it's economically infeasible to build the product. So in any event, so those are the areas. Now the book talks about the Toyota case in product defects. I think it's, let me see if I can find it here. I think it's on the next page. No, it's here somewhere. Let's see. Oh yeah, it's design defects on page 290, design defects 297. You'll read under there the Toyota case, and Toyota had the problem of sudden acceleration. You remember reading about that? And in that setting, they did a recall, a major recall of their cars. And in that setting, they eventually came around and admitted that they had a design defect. I think it was in the braking system of some kind, and it contributed to this sudden acceleration issue that they had. And that was a design defect, and it cost them a lot of money to recall the cars. Anybody that got hurt sued them. Excuse me. And they sued them under a products liability theory, legal theory, and the concept was design defect. Now, the biggest area of all for products liability law and for potential liability is what's known as warnings. You have to give adequate warnings. And what becomes an issue for a jury is what's adequate warnings. What warnings are adequate? And so what you have to do is you have to put warnings on your product for anything foreseeable, and the word is foreseeable, that could be a foreseeable risk of injury during the use of the product. Now that's pretty demanding in terms of what the standards are. But the idea is that these warnings, so you'll see most everything you buy now in a box or any kind of device has got warning labels all over it. Warning for this, warning for that. Those are the lawyers advising the manufacturers and advising the managers that these are decisions you have to make. These are management issues about putting adequate warnings on your product. The whole idea is to try to protect yourself from these suit-happy plaintiffs' lawyers who want to come after every manufacturer for every product, no matter how stupid their client was using it. I guess you know how I feel about that. But in any event, this whole concept of adequate warnings, and I don't know if I mentioned the McDonald's case to you, the lady that burned herself. And in terms of adequate warnings, what did McDonald's do? They put the word hot on the coffee cup. That was the warning, okay? So they were trying to do something to warn you And I think not an argument to you, but I suggest to you that we've got to the point now. How do you protect stupid people? What's the old saying? Stupid is for a long time. And so Mrs. whatever her name was clearly stupid to put a cup of hot coffee between her legs in a car. But she did it, and they lost. And I told you why they lost, because of the how hot McDonald's served their coffee versus the industry. But that aside, the idea of warning people about you. I mean, if you look next time you buy an extension cord, take a look at it. I noticed not too long ago, a new one I bought, and it had a tag on it about 3 inches long, and it went through everything you could possibly do with an extension cord and hurt yourself. And of the 10 they might have listed, 9 were common sense. Basically, the 9 of them were such that if you didn't know those, you shouldn't have a driver's license, you shouldn't be allowed to vote, and you shouldn't be allowed to propagate if you're that stupid. But that's what litigation has done in the products liability area. Don't plug this cord in around water. Really, I mean, that's what it's gotten to be like with a lot of products. You look at if you buy a new car and you look at on the visors, the sun visors. Pull those down and look at them if your car is a year or two old or so. They've got warning this, warning that all over them. And it just reaches the point. There's warnings for the seat belts. There's warnings for everything. And the manufacturers are just trying to protect themselves from these lawsuits. And many of them occur when the question is, what about you as the user of the product? I mean, can't you use a little common sense and use the product for what it's designed for and not try to use it for something else? Now, here's some of the things about adequate warnings. Often it has to do with how you display the warning, where you put the warning, how big is the letters, how clear is the language, are the warnings in different colors? In other words, is the consumer likely to recognize, become aware and see the warning? And even a bicycle, you'll see all kinds of warnings on bicycles now. And when I was a kid, your dad showed you how to ride a bike. You fell on your knees 5 or 6 times. You had scabs on your knees and bloody elbows, and pretty soon you learned to ride the bike. And if you fell off and scraped your knee, it was your fault. And you hit your head on the ground, it was your fault. Your father didn't go running around to his favorite little plaintiff's lawyer and say the bike is crappy. It hurt my son. So that's sadly what it's come to. But in any event, I used to do an essay case, and I don't do essays with you all, of 400. My fact situation was, I called him Jumbo Johnson, and Jumbo Johnson was 450 pounds, and his kids gave him an exercise bicycle for his birthday. And they brought it into the house, and it's in there, and Jumbo gets on the bike and pedals it a few times, and then they all have cake and ice cream, and Jumbo has a gallon of ice cream and eats half the cake himself. He gets back on the bicycle, and the bike collapses. And, I try to be humorous about it and say how well the furniture in the room's destroyed, because you can imagine this 450-pound fat guy falling off and rolling around in his living room. But in any event, it's a products liability suit, and they sue the manufacturer of the bicycle, and they sue Walmart. Okay, but the facts I give them is that Walmart tested the bike up to 400 pounds. Okay, and the statistics is that 99% of the population in the country are under 400 pounds. So they tested it to 400 pounds. Now Jumbo was 450. Okay. The question is, and then I had in the box, there was nothing on the outside of the box, but on the inside of the box they had a red card about the size, and it was 80-pound paper, so it was a thick, heavy card. And let's say it was 8 inches by 10 inches, red, and it said, warning, this bike has been tested to 400 pounds or something like that. So I forget how I did the essay. And yet, I had students say that the warning was not adequate. I had students say that the testing was not adequate, that they should have tested to 500 pounds. Well, maybe they should have tested to 1,000 pounds. And then some of them really did pick it up in terms of some of the defenses. One is that he had knowledge that he weighed 450 pounds. So why should the manufacturer take it in the shorts for a $2 million verdict? Because this jerk got on the bike and didn't read the instructions. In other words, the fact is they got the bike out and hooked it up or set it up, and he jumped on it. And you know how many of us do that anyway? You get a product out of a box somewhere, even my computer. If I ever read anything about my computer, no, I plug it in and start working with it, right? But the point being, the manufacturer, did they do all they could do? And by the way, in those essays, I don't find right or wrong. So students that decided that they didn't test it enough, the only thing I can say is I'm glad they weren't on my jury, you know. And many others would say, wait a minute, this guy weighed 450 pounds. He knew he was fat. He should have been looking at any other instructions or warnings or whatnot. Then I had students who very smartly said, you know what, the big warning should be on the outside of the box. Good idea. They should be in, you know, 48 size font type in big black bold letters, whatever. But the whole idea there is adequacy of warnings. How much is required to warn a consumer? And I shake my head oftentimes with some of the liability cases I see coming out. Now I beat that a little longer than I wanted to. Let me talk about another concept called market share liability. And this is all in the area of products liability, market share liability. Most typically, it's most commonly found in drug cases, drug lawsuits. But it's generally can be found in mass torts. And what mass torts are is mass torts are situations where a product or a compound, a chemical compound maybe, or drugs, which as I said is one of the more typical ones, where the impact of the faulty product or the defective product affects hundreds of people and maybe thousands of people. And those are called mass torts because there's going to be a mass of plaintiffs suing the manufacturer. Now, in that setting, because you've got so many people and the potential damages could be in the billions, and this is public policy, which you know, public policy is an interesting term. It's but it kind of reflects our view of things, and we kind of have a view now that if someone gets injured or hurt, somebody else ought to pay for it. And I have a little difficulty with that concept, but that's the way it is today. And so public policy says here that in that setting of a mass tort, and let's take drugs, they've adopted, some states, not all states, but some states have adopted this market share liability where they say, okay, let's say you have a drug A, and drug A, it turns out, has caused medical problems for a large number of people. The drug is made by 5 different companies. The award is for $5 million. Market share liability is set up so that the company with the largest market share pays the largest part of the verdict. So if it was a $5 million award and Merck had 50% of the market, then they'd be looked at to pay 250, did I say 500 million? I'm sorry, did I say 5 million? They'd be looking at to pay 2.5 million of it. Now let's suppose little company C, they had a 10% market share. So their piece is $500,000. They'd be asked to pay 10% of the $5 million verdict. So they, you know, 500,000. That's market share liability. Now the public policy is that in a mass tort, and in a mass tort, meaning thousands of people, you're going to get settlements or verdicts in the range of the billions of dollars. So you're going to be talking, you know, you could be talking 500 million, but generally you're talking a billion, 2, 3, 4, $10 billion. And the idea is for one company to get hit with that could put them out of business. So the public policy is we're going to spread that loss among all the drug companies. It's the same drug now. They all make the same drug. But they haven't been able to prove which company's drug, in other words, the poor manufacturing, which is the component, what factory, what laboratory was that done in? So the plaintiff just has to show that the product was defective, and he shows that by the medical records and medical reports from the injuries it caused to his client. And now under strict product liability, the manufacturer's liable, and in this setting, because you can't determine exactly who that manufacturer was, then they're going to share the liability, and the basis of the allocation is depending on their market share. Now, there was a case, not in this textbook, and another one that I used to use at one time, where Eli Lilly was one of the defendants in this case, and it was a defendant in a lawsuit. They tried to get out of the case. The judge would not let them out on a motion to dismiss. Eventually, they proved that they never even made the drug. They didn't make the drug. Now, I haven't read the case in detail, so there may be something more to it, but it makes for good gossip, because under the little blurb of the ruling we had in the textbook, they got held responsible to chip in under market share liability, and they didn't even make the drug. Now, I'm pretty sure that those facts, I'd like to know what a court did to distort it, or whatever they did to torture it to include Eli Lilly, but Eli Lilly was a big drug company, makes plenty of money, and so they stuck them in the verdict against, they were a party, and they wouldn't let them out, and then they applied the allocation against them. So sometimes it goes a little too far. Sometimes it goes too far. But again, the whole idea with product liability is to spread the risk, hold the producers to a high standard of care, a high standard, where if they have product defect, they're going to be liable, period. There's not going to be any excuse. Now, having said that, let's go to the defenses, and this is going to be a short one today, so I'm sure you're going to be excited about that. Okay, here are the defenses, and the defenses are over on page, they're in section 4, defenses to product liability, on page 302. Now, I want you to know these. These you're going to need to know. I need to know when I give you the name, and I want you to tell me what it stands for. Okay, you're going to see this. Likewise with the strict liability is an important thing. Now, I don't need you to memorize the 6 requirements, but I would memorize a couple things about them, important things about them. One, of course, would be the aftermarket. If there's aftermarket work done on the product, that would be one I would think about. And was it unreasonably dangerous, just the kind of product it was? And was the defendant in the business of selling it? Because you might have someone in the chain that wasn't in the business. But so you need to know the concepts and theories behind it, why they have strict product liability. Okay, and it tells you that on page 296. It says strict product liability and public policy, and you need to know what that public policy is. And it is that consumers should be protected against unsafe products. Manufacturers and distributors should not escape liability for faulty products, and the manufacturers and sellers are in a better position to bear the costs, meaning they're in a better than the people that get hurt, who may or may not have medical insurance. The policy is these companies have money, they have market share, they should be required to chip in for the damages. So know what those are on 296, what the public policy is. There's 3 items, easy to know, easy to remember. You need to know what design defects are. You need to know what manufacturing defects are. And then when I come over to the defenses, let's talk about those. There are 5 defenses. I want you to know them all and the status of them all. And the first one is called assumption of risk. Okay, so you can make the argument in my Jumbo Johnson case, the 450-pound fellow on the bicycle, that the argument would be that there's 2 things you need for assumption of risk. You need knowledge, and you need to be a volunteer. Meaning that Jumbo, your argument would be Jumbo was knowledgeable that he was obese, and voluntarily got on the bike, that's when assumption of risk could apply. He knew that he was extremely heavy. He got on an exercise bike, and he just started riding it without any thought about how expensive it might be. I don't know why my nose starts to itch when I talk to you all, and I apologize for that. But it itches every single time that I get on this screen. So I really do apologize. And it's getting to be maddening, but I'm not going to blow my nose or whatnot in front of you. But please accept my apology for that. It just starts tickling. Anyway, okay, so assumption of risk, someone who knowingly and voluntarily assumes the risk, even if it's unreasonable. In other words, even if the danger was, clearly, this was a dangerous thing to do, and he did it anyway. So that's assumption of risk, knowingly, voluntarily assuming the risk. Okay. The next one's called product misuse. Now, this one, in my mind, is way out of whack, but product misuse to me makes a lot of sense. Product misuse is using a product for something it was not designed to do. Okay? For whatever reason, the courts, the Supreme Court including, has severely limited this defense. Now, to me, that's kind of like removes the defense of common sense. I'll give you some bad example. A bad example would be a lawnmower, and a person has a lawnmower and they're mowing their lawn, and over on one side there's a little mound of where the grass has died or whatnot. There's got a little bit of a mound there, and so he says, well, you know what? I know the blade flies around. I'm just going to run the mower right over that, and I'm going to smooth that right out. I'm going to knock off the top of that little mound of dirt, and I'm going to have it smoothed down, and then I can replant it or whatnot. And he does that, and rocks fly out from under the mower because he's hit a little dirt spot with some pebbles or whatever. And the neighbor's little boy is playing in his yard next door 15 feet away, and a rock hits him and injures him. Now, is that product misuse? You're damn right it's product misuse. But not very much anymore. The courts have really limited this product misuse. Now, probably my example, which is extreme, would probably fit in there. But there are many other cases where people really are misusing something, not for what it was intended to use, and they got hurt, and the manufacturer still got held liable for that. So that's product misuse. Now, let me go to on page 303, and I'm going to get this case out where I can look at it. So take a look yourself. 303, and you'll see 303 down the bottom says it's this tragic case. Excuse me, it's a tragic case, and it's a story about a little girl who, 5 years old, was riding in the back seat of her parents' car. She had on a 3-point seat belt designed by Ford, but she was not sitting in a booster seat, and the car was involved in a collision. As a result, she suffered a serious spinal cord injury and was paralyzed from the waist down, a 5-year-old little girl. Well, clearly that is a horrible, tragic thing to happen. But let's look at it from a liability standpoint. Let's look at it from a product's liability standpoint. Should Ford be responsible for that? Now, it goes on to say, the family filed a lawsuit against Ford alleging that the film spool, which I think is how the belt rolls up, it retracts, in the vehicle's seatbelt was defectively designed. Ford claimed that Cheyenne had misused the seatbelt by wearing the shoulder belt behind her back, and argued that Cheyenne would not have been so seriously injured had she been wearing the seatbelt correctly. So basically what apparently she did was she had the 3-point over your shoulder and down, buckles, I guess, beside, well, it's 3 points, so I guess it buckles in the same place, yeah. And then she's got across the lap, I suspect. And apparently she took the crossing piece and put it behind her back and buckled herself in so that her waist and everything was, her legs were buckled in, but the belt was behind her back. So Ford said she had not been so very seriously injured, she'd been wearing the seatbelt correctly. The court, however, ruled that Ford could not assert a product misuse defense. Cheyenne was too young to be negligent, and it is reasonably foreseeable that a child would wear a seatbelt incorrectly without understanding the risk. Therefore, even if Cheyenne's injuries resulted from the improper use of the seatbelt, the manufacturer could not avoid liability. Now, I look at that a couple of ways. One is, she's 5 years old. Now, I have a daughter who's got some young children. She's got kids that are 7, and she makes sure they're buckled in right. She doesn't, so, it's kind of like, okay, what about the parents? How are they allowing this little child to sit in the back seat and not have her buckled in properly? Okay, so now was Ford supposed to foresee that the parents wouldn't, what were they going to do? And so you get out results like this sometimes because the facts of the case are so horrible or so tragic. They had a case in Newport Beach about 15 years ago. I'll never forget this. Now, those of you who go to the beach, and I'm sure probably many of you do if we're all Californians, but you go down to the beach and you're sitting on the beach looking out at the ocean, and what do you see about every 3 minutes or less? Is you see kids of all ages and you see men and women, mostly men, say 30 and under, down to 6, go running down the beach and high step into the water and dive into the water, right? We have storms on the coast, right? And when the storms come in, the waves start pounding and the sand gets moved around. And so sometimes the sand isn't where it was. It's in different places. Or it builds up in an area where it hadn't built up before. So now how many times have you sat and watched at the beach, particularly the young kids, run down, take 5 or 6 or 7 high steps as far as they can go before the water gets too high from there, and then dive head first in? Well, they had a young boy about 15 or 16 at Newport Beach about 15 years ago, goes running down the beach, down to the water's edge, goes high stepping through the water, dives in, and he hit his head on a sandbar and paralyzed himself. He became a quadriplegic. The city of Newport Beach was sued for the condition of the sand under the water and lost. And in my mind, they lost because a jury felt so much sympathy for this kid. Now, was it tragic? Yes. Was it going to be very expensive to maintain this young boy for the rest of his life? Absolutely. But where is it written that the city of Newport Beach should pay for it? And then, so what do? You put signs up everywhere saying don't run and jump in the water? I mean, it kind of makes me wonder. And of course, you know what a lot of the cities did then? They turned around and deeded their beach to the state and let the state pay for it. Where's the common sense? Where's the comparative negligence, which is the next one I'm going to talk about, is comparative negligence. But anyway, you may not agree with me, and I understand that. Everybody has their own view of things. But the Ford Motor Company case troubled me a little bit because I felt it was holding Ford to a standard that, now, could Ford foresee that, let's take that through the steps we talked about earlier. Can Ford foresee that a child might put a seatbelt on improperly? Yeah, I think you could say they did. Well, then what is the alternative, the less dangerous alternative to the system they have, which, by the way, was approved by the Department of Transportation. Okay, you had to get your seatbelt designs approved by the government. And is it economically feasible? So what kind of seatbelt system did Ford have to put in? Would you hold them to put in a proper standard to avoid a product's liability in a situation like this? And that's a hard one to know. To me, it's economically impossible. Could you foresee a child put the belt on wrong? Yeah, you can. But how do the car doesn't come with a guy sitting in the back seat who buckles everybody up. Hi, I'm from Ford, and we're a full-service company here. And by the way, let me get your seatbelt on properly. I mean, what was Ford supposed to do? And so there's your situation of this product's liability and product misuse, or in this case, you'd even have. But I think, of course, you'll remember from their decision, they said about a young child. You'll see where they said Cheyenne was too young to be negligent, So now if she can't be negligent, then you can't apply comparative negligence as a defense, which I'm going to show you in just a moment the way you would do it. So it said that she could not be negligent, and it is reasonably foreseeable that the child would wear a seatbelt incorrectly without understanding the risks. Well, I understand, okay? But what about the parents? What are they doing? It's a safety feature. Why aren't you sure your kid's got the belt on right? Or what do you do if the parent belts him in right and the child pulls out from under the belt and puts it behind him, and they're driving along, they don't even notice it? That's Ford Motor Company's fault. Okay, but yeah, let me tell you something about this product liability stuff. Because every time there's a big verdict against a manufacturer, and this always blew me away when I came to California, because my litigation work I did in Pennsylvania, different environment there, and I couldn't get over some of the cases that got the juries and got the trial in California that would have been thrown out in Pennsylvania. Because out here there just seemed to be nobody's at fault for anything. The people with the most money are going to be at fault. We can figure out a way to tag them. That's what we'll do. And I'm beginning to forget what my point was, but in any event, you don't get those kind of verdicts back east that you get out here. And I recall my point now, and that is, a lot of people think, oh, well, like it's the insurance company. Just nail the insurance company. Or it's Ford Motor Company. They have a lot of money. So we'll get them. Who gets hurt? Who gets hurt? All of us. Because our new Ford the next year cost another $500 because you think they're not going to put this into their price somewhere? If they paid out a $10 million judgment for a case like this, don't you think that's going into the cost of the product? It's, maybe it's not cost of goods sold, but it ought to be. I don't know where I'd put it on the accounting line, but you would kind of figure that into gross profit margin. At least I'd be inclined to, because now you're paying money for your product being defective. So the point being that anytime a manufacturer gets hit hard for a big number, it's going to get passed through to the consumer. It's that simple. They're not going out of business. They're going to pass it through. So the person who pulls this, and like Newport Beach, and the poor kid diving into the sandbar and crashed, breaking his neck. And Newport Beach is just going to raise their taxes, or they're going to, if you want to go to the beach now, it's going to cost you $25 instead of $10, because they're trying to recoup that money that they lost paying that judgment. So anyway, I guess I'm whining about it now, but it makes me wonder sometimes. But anyway, because there are arguments on the other side that Ford should still be responsible, but I would submit to you that the primary motivation for Ford being responsible, excuse me, is the medical costs this family was facing for this 5-year-old little girl and her being paralyzed or not. It's a horrible, horrible thing, but basically it looks to me like the court said, well, let Ford Motor Company pay for it. They can afford it more than the parents can. Well, okay, that's the way the world's going to work. So now, comparative negligence. And in this case, they apportion the liability among the plaintiff and the defendant. Okay, so that if you have something occur and the defendant also did something stupid with the product, then they contributed to their injury, then the court's going to look at that and make it contributory negligence. I'm trying to think. I had a case not too long ago that was in one of my books where, but it's a little complicated to explain on the screen, but it was misuse of a product, and the operator of the heavy equipment that was misusing the heavy equipment to do something that shouldn't be done, he ended up getting electrocuted because he touched some wires with the boom that he normally wouldn't be operating the boom under the wires. And the court found comparative negligence there because he knew how to use the equipment. He was using it for something he shouldn't have used it for. They still found product liability and still found against the manufacturer of this piece of heavy equipment because they said that they should have insulated some of the metal in the boom that came in contact with the electric lines, which caused the electrocution. But they also found that the operator was knowledgeable enough that he should have known better, and so they allocated the verdict. And what a jury does is when they do their deliberation, let's suppose they looked at this case, the one I just mentioned of the machine operator, and they said, well, we're going to award this guy $500,000. We're going to award, it's going to be his award on the lawsuit, products liability lawsuit. But then they say, but you know what? That's what he should get. But we have to reduce that because of his conduct, which contributed to his injury. And in that setting, a jury might say, you know what? We think he was 20% responsible, or we think he was 25 or 30 or whatever it might be. But we think, I mean, you could have a situation where the jury says, you know what? I think he was equally responsible. I think the product was, I think they designed the equipment, it had a defect. They should have insulated some of the wires up there because it's foreseeable that the boom could be up there, be raised to an area where it might come in contact with some electrical wires. So they probably should have been able to foresee some of that, and therefore we're going to hold them responsible too. But you know, we think this guy was using the equipment improperly, and so we're going to make it 50-50 split. So they awarded him $250,000 after they'd come to the conclusion that if he'd had no contribution to the problem, they would have awarded him $500,000. So that's how the comparative negligence works. They allocate the award depending on the amount of contribution towards the injury that the plaintiff might have made. One other point again on product misuse, because of the way the courts have so restricted its application as a defense, and that is now they require the manufacturer to build and design their product in a way that not only is it safe for any foreseeable use, but also for any foreseeable misuse. So there are now cases that come down that say that so-and-so misused the product, and that was foreseeable, and they should have done something to protect them further. So in other words, now manufacturers are looking at various products they put out, particularly ones that might be inherently dangerous, like a chainsaw, and they're having to look, what could this fool do with this product that's misused that we can save him from himself, because now product misuse severely limited by the courts, and now you've got to look out to see whether there's any you have to probably, I guess, look at your product and say, okay, what else could this be used for? You know, I mean, can this be used for a doorstop, or you know, can this be used to put my car on top of it so I can change the oil? I mean, or is it just for a chainsaw? Whatever else could you do with it? You know, mow the lawn. So they've got to, so then do I have to put a different kind of guard on it, or what kind of warnings do I need to put on, that sort of thing. So you're having to go out as a manufacturer, as a manager. This is a legal issue for you to face, is in terms of potential liability of your company for what the product you make, and so you've got to design it for possible misuse, believe it or not. So anyway, now the other one, the next one is called commonly known dangers. Okay, so here are your defenses: assumption of risk, product misuse, which is narrow, but it is there as a defense, and it has worked in places. Comparative negligence, where you're allocating responsibility so that the injured plaintiff made his conduct had something to do with the injury, with the accident, and then his injury, and therefore you're going to deduct off of his award. And the common known dangers, and those are the ultimate in stupidity, like a knife. Everybody knows a knife is sharp. You can't sue a manufacturer of a knife or a knife set, like, you know, families have a nice knife set on the counter in the corner somewhere with a bread knife and a paring knife and what have you. And many of them, most of them, are very sharp. And so you pull out a knife and you cut yourself. Well, that's a commonly known danger. So, matches. You burn yourself with matches. Hello? That's a commonly known danger. You can't sue the match company for any reason. There's a case in here about the lady who got one of those elastic bands that you exercise with, and I guess she had it on her foot, anchored it with her foot, and she was doing something on the floor, and it slipped off her foot and came up and hit her in the face or something and injured her. And she sued on that, and that court said, no, that's a commonly known danger. I mean, thank God, you know, I mean, there's a little common sense left. You put this thing down in your foot and you anchor it, and it slips off because you move or something and comes right back and whacks you in the face, you know, okay, that's a common known danger. So we can't help it. So whatever. So now another one is a knowledgeable user. And the simple, easiest one to remember is the electrician. And I think the book talks about the electrician, where the electrician's out there working and he shocks himself. Whether he electrocutes him or doesn't die, but let's say he shocks himself badly, or a minor electrocution can cause damage to nerves and one thing or another. And so he wants to sue the maker of one of the tools or whatnot that he uses. And under the concept of knowledgeable user, he's knowledgeable. He knows. And in fact, I had some students in my Jumbo Johnson case, which I thought was pretty clever, came out and say Jumbo was a knowledgeable user. He knew he was obese and he got on the bike. And forget about assumption of risk. He knew that he was fat and obese. He knew he weighed 450 pounds. And that's his tough luck because he was a knowledgeable fat user. Anyway, I'm not being very kind to Jumbo tonight. And of course, the worst case, which is also in your book, is the McDonald's case. Let's see if I can find it here, where they sued McDonald's. Where is it here? Oh, case in point. Let me see if I can find it here, because I wrote it down about. Here it is. It's on page 304 under knowledgeable user, case in point, and it talks about the parents of teenagers who had become overweight, developed health problems, filed a product liability suit against McDonald's, claiming that they'd failed to warn customers of adverse health effects of eating the food. The court rejected the claim based on a knowledgeable user doctrine. The court found it's well known that the food in McDonald's contains high levels of fat, salt, and cholesterol and sugar. And the court's opinion, which thwarted future law firms against fast food restaurants, stated if consumers know or reasonably should know the potential ill health effects of eating at McDonald's, they can't blame McDonald's if they nonetheless choose to eat there. Boy, oh boy, some common sense from a court in the United States of America. Isn't that a wonderful thing? And I saw those cases coming a long time ago. And of course, you know the idea here in the great USA, not my fault. Blame somebody else. And that's got to be the biggest piece of lunacy I've ever seen. I'm really getting out of shape here tonight, folks, so just bear with me. I'm almost done. You can go to bed. All right, and the last thing. So here are the 5: assumption of risk, product misuse, comparative negligence, and commonly known dangers, and knowledgeable users. The electrician example. Then the last concept is called the statute of limitations. The one I want you to remember is statute of repose, R-E-P-O-S-E. It calls it that in the book on page 305, the statute of repose. And here's what the statute of repose is all about. For a long time, there was no statute of limitations on product liability cases. And the idea was that, a product, a drug, let's say, you might not have an ill effect for a year, 3 years, 5 years. It could be a while before that drug started to develop negative reactions to people where they got enough reports of it that someone said there's something wrong with this drug and we need to check it out. And so you had an unended potential liability. Now, from a financial standpoint, from a company's financial standpoint, how do they reserve for that in their financial statements? So if they sell, millions of pills of some kind, and there's the prospect that there's going to be something wrong with the composition of the chemical 5-10 years from now, how do they know when they're going to, when are they ever going to be able to take this out as a contingent liability? And that's what the statute of repose is about. Excuse me. And what it does is it puts a 12-year statute of limitations from the date of the sale of the product or the date of its manufacture, whichever happened last. I think it's last. Let me check it. Well, my other book used to say that. But I think it's whichever happens last. So from the date, it's 12 years from the date the product was sold or the date the product was manufactured, one of those two. So that after that, you're barred from bringing any action. And 12 years is plenty of time. And so the idea is to give people the manufacturers and the people who are making these products, some sense of how long they're going to be on the hook and be liable for any injuries that occur because of their product and the use of their product. Okay? So that's the statute of repose. You need to know what that's about. So we've got our 5 defenses. You've got your 6 requirements to show a product's liability, a strict product liability. Remember, you've got manufacturer's defects, you've got design defects. The big one is inadequate warnings. And you might get a question on whether you think something's adequate or inadequate for warnings and so forth. Market share liability is another important concept to know about. So again, strict liability is the ultra-hazardous danger, abnormally dangerous, the blasting cases, and so forth. And then with product liability, if you're a plaintiff, you can sue on 3 bases: on negligence, on misrepresentation, and then on strict liability. And the reason you'd sue on all 3, but the reason you'd go for the strict liability is because strict liability is what it says. It's strict, and so the defendant manufacturing company has fewer defenses to put up. Strict liability is very strict. They have to be within a very narrow confine, or they're going to be liable. So that's the concept of strict products liability. All right, so that looks like about everything I want to cover tonight. The second part's going to be intellectual property, and I'll probably be getting to that first thing tomorrow, and I'll get that on here for you to look at. So anyway, I hope this has been somewhat interesting, and it certainly is a very, very dangerous area of the law for people who are making various products and putting them out in the marketplace. They're just plaintiff happy lawyers out there who are going to maintain that their client, the client's lack of common sense didn't make any difference because the product was just dangerous, and besides, you got a lot of money, so we'll sue you and see if we can settle and get a few $100,000 out of you. Anyway, I will talk to you all again real soon on intellectual property, and have a good evening. Bye-bye.